Good morning, everybody, and welcome. I'm Erica Frank. I'm of counsel at the Shaw Law Group, and with me today is Rashida Harmon. She is the guru over at the California Civil Rights Division. I almost said it, Rashida. Her official title is the Senior Fair Employment and Housing Counsel in the Education and Outreach Unit of the Civil Rights Department. And for those of you that hadn't gotten the announcement yet, the Department of Fair Employment and Housing is phasing out their name and is rebranding itself to the Civil Rights Department. So for some of you veterans such as myself, it's going to take me a while to get used to that name. And I may still revert to the old one. I was at my high school reunion. I'm not going to tell you how long because then you'll know how old I am. But I still refer to my friends from high school by their maiden names, right? Even in my phone. I'm like, it's just the way it is. Okay.
The way it is.
So Rashida, welcome again. It's been so much fun. And of course, go ahead, you can throw me out there. And as most of you know, I'm Erica Frank. I'm an attorney at the Shaw Law Group. I've done quite a bit of trainings. I'm here over at the firm. It's been over a year now. It's been fantastic, offering advice, counseling. Of course, you know I love to train, so here I am today. And then what I think is so fantastic about the topic we're going to talk about is workplace investigations. Not only is that something that our firm does do on a regular basis, we have several attorneys, including myself, who conduct workplace investigations, but we also have a training that is going to be launching, I believe it's next week. I'll look, we have the date at the end of the slide, but so this is just a great lay the foundation, give you all a sense of what you need to know, and then you can go sign up for the more intensive 3-day session. Go ahead, Rashida. So Rashida and I are going to be tag teaming today, giving you all sorts of fantastic information about conducting workplace investigations because, you know, at least in our practice, we've seen a very large increase in the number of workplace investigations that have been transpiring. Now, of course, today we'll be focusing primarily on harassment, but the duty to conduct workplace investigations is not limited to just harassment, of course. Just claims of discrimination, abusive conduct. Sometimes we get retained just to evaluate workplace culture and what's been going on in the workplace. So even though we're providing you with a lot of great information, we all know that we are not providing you with legal advice at all. I have the question queue on. I'll try to address those questions as I can, but I'm still not going to be giving you any legal advice. You've got to reach out to your counsel, and please add the last, excuse me, tongue-tied, as the last bullet notes, please reach out to counsel before you make any changes to your policies, practices, or procedures.
Yes, and similarly, on behalf of the CRD, I want to note that this guidance is for informational purposes only, does not establish substantive policy or rights, and as Erica just pointed out, does not constitute legal advice. So I'm just going to launch really quickly into some CRD 101 things. I think probably most of the audience is aware of this, so bear with me. But the mission of the Civil Rights Department, formerly DFEH, is to protect the people of California from unlawful discrimination in employment, housing, at businesses, and state-funded and administered programs or activities, and also from hate, violence, and human trafficking. Eric already pointed this out. We changed our name. We are now CRD, and we're all getting used to it, so no worries at all. We have many responsibilities, including investigating complaints of discrimination and cases of systemic discrimination. We facilitate mediation and dispute resolution involving civil rights issues. We enforce the laws by prosecuting violations in civil court. We issue regs. We collect data on pay and demographics for large employers' workforces. And we do what I'm doing right now, which is public outreach and training. So I'm not going to talk about all of the laws that we enforce, but I did want to highlight our old pal, the FEHA. This is codified in the government code, and as many of us on this call know, it protects individuals from housing and employment discrimination and harassment on the basis of protected characteristics. I also wanted to note that it does include additional provisions that protect special populations that wouldn't otherwise be protected. I know that's a confusing sentence. So what I mean, for example, is there's a provision in the FEHA called the Fair Chance Act that protects people with conviction histories in the hiring process in very specific ways, even though being a person with a criminal record is not a protected characteristic under the law. Now, for our purposes today, I wanted to just ground us in some regulations. So back in 2016, the Civil Rights Council, formerly the Fair Employment and Housing Council, enacted regs clarifying employers' obligations to prevent and correct wrongful behavior under the FEHA. So this is codified, here's the site, CCR 11023, which states kind of high level that employers have an affirmative duty to take reasonable steps to prevent and promptly correct discriminatory and harassing conduct. In addition, employers are required to have a harassment, discrimination, and retaliation prevention policy that is in writing, and that also establishes an internal complaint or investigation process. Anything you want to add before I swing over to the next slide?
Yeah, so this is really the, kind of the foundational principles that we as employers need to live by, really honing in on the affirmative duty that we have to look into a complaint or some kind of workplace conduct. Now, the thing that we have to remember is we are not reaching a legal conclusion. Our job is not to say, oh, that's not legal harassment. Just because, the employee said that to you, just go back to work. We really need to evaluate and treat every complaint that comes through as if there is a legitimate concern here. So that affirmative duty is listening, or if we've observed inappropriate conduct in the workplace, taking an effort to look into that conduct and looking in and making those factual findings to see what's going on and whether there needs to be some kind of resolution.
Absolutely, and so we're going to go into that shortly. So let's do a little hypo. Jane is an administrator at a tech company. For the past month, her colleague John has started stopping by her desk a couple times a week to tell her crude sexual jokes. He also sends them over chat. These jokes make Jane very uncomfortable. She tells her closest friend at work, Susan, about the jokes and how they make her feel. Her friend recommends that she set up a meeting with her supervisor and a representative from HR to report John's behavior, which she does. You have received Jane's report. What now? What do you do? The first thing I want to talk about is, okay, you get this report. Are you even qualified to investigate? What does that look like? And so in terms of the qualifications, one thing to say right off the bat is that employers are permitted to use a current employee as an investigator or can hire an external investigator, like Erica and her colleagues. Typically, in instances of harassment allegations, the employee investigator will be someone from HR. And in California, external investigators, so those who don't actually work for the employer, have to be either licensed private investigators or, like Erica, attorneys acting in their capacity as an attorney. Either way, whether this is an existing employee or an external investigator, the person acting as investigator should be knowledgeable about standard investigatory practices. What I mean by this is they need to have some knowledge of the laws and policies relating to harassment and discrimination. They need to understand investigative techniques related to questioning witnesses. They need to understand how to properly document interviews and just more broadly how to analyze information. And I'll also note that when it comes to more complex or serious allegations, it's best practice that they have experience conducting those kinds of investigations. Of course, strong communication skills are key.
And I think, you know, as HR professionals and those of us who are attending, we get a sense of what may be more minor to what could be complex and serious. And oftentimes it also depends upon who the claims are about. Are we dealing with a high level employee, maybe an executive in the organization? That might need a little bit more sensitivity, and that might necessitate an outside investigator, particularly because if the HR individual works closely with these employees, as we'll see later, it's important that the investigator is unbiased. And sometimes that can be really tricky as HR conducting an investigation. So, you know, there are a number of things we need to consider when we're looking at who's going to do the investigation, and who are we going to utilize.
That's a great point. Thank you, Erica.
Mm-hmm.
And so as an investigator, what type of training do you have to undergo? Basically, short answer is there's no standard training program for workplace investigators, but at a minimum, one of these kinds of trainings should cover information about the law shaping investigations, recommended practices, confidentiality and protections from retaliation, how to determine scope, so how to determine what to investigate, how to interview witnesses effectively, factors related to credibility and weighing credibility, how to analyze information, and the mechanics of writing a report.
And just so I can just clarify, when we talk about no standard training program, it's important to note that the law does not require prerequisite training to be an investigator. Now, the law does require if you're going outside of your organization and using a third party, then that third party needs to either be a licensed attorney licensed in the state of California or a private investigator. However, with that being said, as you can see, there's a lot that you need to know before you start to conduct an investigation. And so that's where training really comes into play. You need to have at least some kind of foundational knowledge of what the investigation process looks like. Now, you have done some form of investigation just by Leo being HR professionals, triaging employee issues and concerns, addressing workplace conduct, addressing perhaps performance absenteeism. You know, there's no formal way, right? Investigations doesn't have to be, okay, I'm now conducting an investigation. I mean, you're looking into those issues that transpire. However, once we get into where it is a little bit more formal to the extent that we have a number of witnesses we need to speak with, we're concerned about perhaps someone's protected activity has been violated, and that's somewhat of a strong word, but there's been unlawful conduct in the workplace, then that's where we start to come into these concepts, which of course we're going to cover today. But to really be able to conduct a thorough investigation, training is really important to do.
Agreed. All right, so you've received this report from Jane. What's the sort of overarching plan of action now? You're going to need to evaluate the seriousness of the allegation. If appropriate, you're going to need to launch a formal investigation in order to make factual determinations. This is because minor incidents can perhaps be resolved informally by counseling the individual or individuals, and we can talk a little bit more about that in a moment. Then, of course, at the close of the investigation, you'll have to evaluate and decide on a course of action based on your factual findings. Obviously, you know, these reports should be taken seriously and you should prioritize these types of reports. But in evaluating sort of next steps and the seriousness, you want to consider whether the report involves behavior that, if true, would violate the company's rules, policies, or expectations. In our little hypo here, Jane's report alleges persistent inappropriate behavior of a sexual nature. As a result, it would likely merit a formal investigation. Anything you want to add?
No, I was trying to. Apparently, folks could see my email and calendar, which is a scary thing.
Oh, no.
No one needs to see how nutty that can be sometimes. So hopefully that's taken. I've taken care of that. That's so weird because all I can see is our screen. So hopefully that's, Linda, thank you so much for sharing that. I really appreciate it. Okay, I think we are good.
We're good.
We're good. Keep going.
Cool. So let's talk a little bit about fairness. These kinds of investigations really require and emphasize due process. And so I know a lot of us know what that means, but in this context, we're referring to fairness to all parties. To conduct a fair investigation, you need to conduct a thorough interview with the complainant, who in our scenario is Jane. But you also need to give the accused party, so John here, a chance to tell their side of the story. Due process requires you to clearly state the allegations against them and also give them the opportunity to respond. You're also going to want to interview relevant witnesses, so maybe Susan in our scenario, and review relevant documents. We mentioned that some of this happened over chat. You're going to want to review chat logs if possible, see if Jane has notes, text messages, or other documentation of what John said to her and when. Find out whether anyone else in the office is aware of what happened, you know, who sits around Jane, those kinds of things. But one thing to note is that an investigator does not need to interview every single witness or review every document suggested by the parties. The investigator has discretion. The goal is really to interview any witnesses whose information could impact the findings of the investigation, and also to attempt to gather any documents that could reasonably confirm or undermine the allegations or the response to the allegations.
So Rashida, I just want to jump in here really quickly because we've received a couple of similar questions regarding who can investigate. And then there was another great question that is pertinent to, you know, why we need to investigate. So a number of you have asked whether an HR consultant can conduct the investigation. An HR consultant cannot unless they are also licensed by the state of California as an attorney or a private investigator. So that is extremely important to remember. You might be utilizing the resources of an HR consultant, which is fantastic, but unless they are licensed to practice in the state of California or a licensed private investigator, they will not qualify as an investigator for these purposes. Other great question that came in was, what if a manager observes the inappropriate conduct? Is an investigation still required? And the answer is yes. So if a manager observes inappropriate conduct, the manager first needs to report it and go through your complaint process, which we can touch upon today. And then, of course, the investigation isn't just seeing, it's also talking to other witnesses, finding out what happened, as Rashida just talked about, you know, really getting the fact gathering so that you can make an assessment as to, and we'll talk in a moment, is it more likely than not that this allegation took place?
Exactly. These are great questions, excuse me. So keep them coming.
Yep.
Let's talk a little bit about confidentiality, because I know people tend to have questions about this, and it's a little bit hairy. So can you keep the complaint confidential? The short answer is no. Okay. Employers can only promise limited confidentiality. In other words, that the information will be limited to those who need to know. This is because in the course of the investigation, it might be necessary to disclose information in order to do the investigation and take action. But also, you know, in the process of investigation, people will probably figure out what's going on. You'll either know or assume details about the allegations, who's involved, who complained, those kinds of things. And importantly, you will likely have to consult with someone else at the company, maybe the accused supervisor, et cetera, about what steps to take, and also to collect information about, you know, whether there have been past complaints involving similar conduct and the same employee, et cetera. So there's a lot of stuff going on there, but short answer is no, the complaint is not going to be strictly confidential. And of course, if the company has to take disciplinary action, again, people will likely suss out what happened. Can I tell employees not to talk about the investigation? Again, it's really complicated. Okay, so you should tell managers to keep the investigation confidential, but it's really important to note that courts have determined it's generally inappropriate to require employees to keep complaints like this secret. This is because employees have the right to talk about their work conditions, right? That's a good reason. But there are some exceptions. So we recommend, if you want to require confidentiality, it's best practice to speak to an attorney to figure out whether it's appropriate and how to go about it.
As I want to touch upon on this topic and to really tease out what we're talking about here when it comes to confidentiality. So as the investigator, so when I'm wearing my investigation hat, I can't promise confidentiality to anybody I'm speaking with, even the complainant, for the sheer fact that as my job as an investigator, I have to share the information that I've been provided. Now, with that being said, it can be very scary for any employee to be involved in an investigation, whether they're a witness or they're a respondent. The respondent's who we call the accused, or the complainant, the person who's bringing the complaint. It's scary no matter what, especially when they're like, who are you? You're an attorney and now you're talking to me about work. What the heck, right? So, it's important to realize that as the investigator, we can't maintain confidentiality. Now, of course, we do our best to do so, and we're going to refrain from telling people, oh, Rashida told me that in the break room, you said this. Rather, we will be, a witness informed me, or it is my understanding that. Now, when it comes to the employees, and this is where Rashida was talking about things being complicated. In general, under California and federal law, employees have the right to talk about the workplace. Okay, we can't silence an employee's ability to talk about the workplace. So if an employee wants to share that they filed a complaint, they're more than that. That is something they are absolutely entitled to do. When it comes to speaking with an investigator and having a discussion about the investigation itself, although it is about the workplace, and Rashida did touch upon it, it is still important that they maintain the confidence of what we talked about in the questions that the investigator asked, because we need to ensure that the investigation is not compromised, so that when we're talking to other witnesses, and one of the things that I always do is, have you talked to anybody about this? Who have you talked to? It speaks to the credibility of the witness and the validity of their, of their testimony. There was a question here, Rashida Trish, who wanted to know, at what point do we recommend speaking with the accused? Right after talking to the complainant or after talking to witnesses? So Trish, every investigator is going to have their own practices and ways within which they conduct their investigation. However, as a general rule, most investigators, including myself, will speak with the respondent last. It's more efficient that way, simply because you have now spoken to everybody and you can ask the respondent all of about not only the complaint, but what you've heard from witnesses. Now, of course, you can certainly talk to the respondent, and sometimes what happens is you speak with the respondent and the respondent gives you even more witnesses, and there's a lot of back and forth, which Rashida is going to be talking about. But remember, the respondent needs to have that opportunity to tell their side of the story. So that's some results. We'll get to that one later. Okay, great question. Is there a provision anywhere that says the investigator needs to provide the complaint or allegations before interviewing with the respondent? So what we have to do is notify the respondent that a workplace complaint has been made against them, as well as a general statement. That is something we do need to do so that they know that this is coming. And for those of us that have union employees, they have the right to have a union representative attend the investigation processes. So that's what we were speaking about there. All right, why don't we keep going and then we'll swing back and get to some of these questions.
Cool, yeah, I love the level of engagement. What if Jane herself, the complainant, asks you not to do anything as the investigator. It's rarely appropriate for an employer to decline to investigate a complaint simply because the employee asks them not to, right? As noted, if the complaint involves relatively minor allegations and the complainant wants to sort of handle it themselves, they can be coached on how to do that. But the employer should make an effort to follow up and ensure that this happened, and also assure that the alleged conduct has stopped. However, if the allegations are more serious, the employer will have to investigate the facts so it can take appropriate action. In those cases, it's not acceptable to have the complainant handle the matter alone. Let's talk about timelines. What does the timeline for an investigation look like? The investigation should be started and conducted promptly, as soon as is feasible. And there's a bit of a balancing act here, right? So you want it to proceed and conclude quickly, but at the same time, investigators also have to take the time to ensure that the investigation is fair to all parties and is thorough. Promptness is important, however, because it assists in stopping harassing behavior, sends a message that the employer takes the complaint seriously, helps ensure the preservation of evidence, which is important, including both physical evidence like emails, videos, chat logs, things like that, but also witnesses' memories, which tend to fade or become less reliable over time. It allows the employer to fairly address the issues in a manner that will minimize disruption. Oh, that's it for that one. Anything to add, Erica?
You know, this is a nice overview of some of the reasons why. I mean, the other thing is, if we've got a complaint, you know, it takes a lot for the complainant to come forward. They're probably very nervous anyway and just want to, quote, unquote, get this over with. So you never want to be sitting on a workplace complaint, just because there could be other things that are percolating. It could lead to some more serious behavior. It could be a situation that at the moment you've determined it more than likely did not occur, but at the same time, it could eventually occur to something much bigger. So there really is no reason to delay. That's really just pretty much the bottom line. If you receive a complaint, you start inquiring and starting the process.
Exactly right. So here are some recommended practices for conducting workplace investigations. The investigation should be impartial. Findings should be based on objective weighing of the evidence collected. It's important for the person conducting the investigation to assess whether they themselves have any biases that would interfere with coming to a fair and impartial finding. For example, in a case in which the investigator has a personal friendship with the complainant or the accused, whether actual or perceived, the investigator may have to recuse themselves or be recused to avoid the appearance of impropriety. It's generally a bad idea to have someone investigate a situation where either the complainant or the accused has more authority in the organization than the investigator. Anything to add there, Erica? I thought I heard you.
Let's just kind of talk a little bit about this slide, because it's extremely important, especially if those of us conduct in-house investigations. You know, as HR, and whether there's all these great titles now for individuals who are in the human resource professional, and I love all of them, but I'm not even going to try and pretend like I can, you know, think of them right away, because I'm still stuck in the HR world. But as HR, we have to struggle with biases all the time, right? So we have to make sure that our employees, when they come to speak with us, know that we're advocating for their behalf, even if we're reporting to the C-suite, even if we have a good relationship with the CEO or the CFO or whomever it may be. However, there can be times when a complaint is crossing your desk and it is against somebody or involves somebody for whom you do have a close working relationship with. take, for example, you report to the CFO and it is an allegation involving the CFO. It's going to be really hard for you to remove yourself from any biases that you may have. And we do have a slide where we'll talk about what the different biases are. And that's a situation where you really have to think about whether you're the most qualified, but whether you're the best person to conduct the investigation. That also starts to mold into that impartiality, where if the complainant knows that you have a close relationship with the CFO, it's going to be very hard for you to be that neutral fact finder. And that's where it's time to find somebody external or somebody else who may be qualified. A number of companies, and many of yours may already have an EEO department, equal opportunity department. I know many public agencies have EEO officers now. And part of that is so that that EEO officer is insulated from all of the other human resource matters and issues that are dealt with that may make it difficult for that EEO officer to stand in an impartial, biased shoes to conduct the investigation. All right, roll. We're good.
Cool. Turning now to the various types of questioning. One thing that we want to emphasize is that investigations are not interrogations. Neither the complainant nor the accused party should feel they're being cross-examined. I know Erica already mentioned this, but this can be scary and intense for people to have to, participate in one of these investigations, regardless of their role in the investigation. And so you don't want to exacerbate those fears by treating it like an interrogation. We recommend using open-ended questions and questions that really get to the who, what, when, why, how, maybe where.
Where. Yeah, I forgot the where in there.
It's important.
So this is one of those skills that a training course can really help hone in on, because it takes some time to get used to being sort of a nosy person. I mean, that's really that is really what you become. You have to find out everything about what's going on in the situation. And it's really easy for us to say, Rashida, did you say this inappropriate comment in the break room? Instead of, Rashida, tell me what happened when you walked into the break room. Who did you see? Who did you speak with? What did you say to that person? When did you say to that person? What did that person say in return? So it is, really, it's a very patient process. It's a very strategic process, but you're letting the person you're speaking with tell the story as opposed to you leading them on to tell the story that you think should be told.
Okay, credibility determinations. So what are some factors that speak to a person's credibility? These factors include inherent plausibility. Are the facts believable that they're talking about? Does this person have a motive to lie? Is there any kind of bias or personal interest or other motive that might give them, an incentive to lie, let's say? Corroboration. Has their account been corroborated by other witnesses, by documentary evidence, etc.? How well were they able to perceive, recollect, or communicate their story? Where were they? What else was going on? Was this a room with one person in it, or was this a busy open air office plan? Those things can factor in here. Do they have a history of honesty or dishonesty? And I want to make clear that the point here is not to make judgments about a person's character, but just to factor that in for context. Things related to habit. Is this something that happened regularly, frequently? Was it every Wednesday in the same place? Things like that. Consistency of statements. Has the witness contradicted themselves elsewhere in their testimony? Manner of testimony. Are they giving indirect answers to some questions but not others? Maybe that will factor in here. And then finally, demeanor. And I have a little asterisk here because basically it's been determined that people are not great at judging demeanor as it relates to credibility. So you do want to apply this factor with caution, but it may be something that comes into play depending on these circumstances.
So one of the things with demeanor and why it's so tricky is you're judging the demeanor of the witness as you're interviewing them. And so, many individuals, when they're nervous, they may appear more stoic. They may appear, they might laugh a lot. They may provide short answers, and it may not necessarily be their demeanor at the time the event took place. Now, with that being said, you can certainly judge or take your notes and observations of how somebody asks the question. So did the person get fidgety as you were asking a particular question? Did they get nervous with their body language and write, how they were nervous? They started to swivel a lot in their chair or adjust their positioning in their chair. Those are certainly things that you can note in your observations and as you're taking notes. But many of these credibility factors actually will intersect with the other. We always love to have evidence to corroborate a testimony. So that could be an email, it could be a chat, it can be a screenshot from a text message. Those are always going to be the strongest credibility factors because you have a written document that's corroborating the statement. Plausibility is piecing all the puzzles together and making it is plausible that, Rashida yelled at the individual in the break room because, so you may not know for certain if it happened, but piecing all of your facts together, you can make that finding that it's plausible, it's possible, it's believable that this happened. All right.
Cool. So let's turn to the burden of proof, which is very, very important. And I imagine Erica will have some great thoughts on this. The investigators should make findings based on the preponderance of the evidence standard. This is the same standard that civil courts use in discrimination and harassment cases. It's also called more likely than not, which Erica pointed out earlier. I also like the sort of cute description, 50% plus a feather. And so what this all means is that the investigator is making a finding that it is more likely than not that the alleged conduct occurred, or more likely than not that it did not occur.
So yes, so I love this slide because it does an excellent job of really honing in on what our obligation as investigators really is. Like, what are we finding? And our findings are whether it was more likely than not A happened or more likely than not that A did not happen. We are not making any legal conclusions. And sometimes that's really hard for people to wrap their head around. Oftentimes we have clients and they'll want, where's the legal finding? But that's not what the purpose of the investigation is. You make your legal finding after you complete your investigation report. And based on the findings of the investigator, then you determine what the next steps will be. Is it discipline? Is it coaching? Or is it termination based on the findings in the report? So remember, and it's kind of tough, especially with many of us that do have a pretty darn good knowledge of what the law says, especially as it relates to harassment, discrimination, retaliation. It's very challenging for us not to put that hat on and make that legal determination. It's great for us to have that working knowledge so we know what types of questions to ask. But at the end of the day, it is more likely than not. Now, 50% in a feather, that's like just barely over 50%. That doesn't mean that you have 99% sure that this more than likely than not happened, but that's not the burden.
Yes, well said. And you just raised this, so this is a good segue. But again, these are factual, not legal conclusions. So during the investigation, John denied making crude sexual jokes to Jane. Chat logs coupled with testimony from Susan, I don't know why I gave her a nickname of Susie here, corroborate Jane's claims. Moreover, 3 witnesses who sit near Jane recall seeing her looking upset and uncomfortable after numerous interactions with John. This is what the investigation found, right? So the appropriate conclusion here would be a preponderance of the evidence supports a conclusion that John did tell sexually explicit jokes. Just to contrast with an inappropriate legal conclusion, that would look like a preponderance of the evidence supports a conclusion that John sexually harassed Jane. This sexual harassment language, that's a legal conclusion, and that is not the goal here, as Erica has succinctly pointed out.
Yep. There was a question here about whether a reasonable belief is the standard. You know, from a legal context, that's somewhat different than a preponderance of the evidence. So I would speak with your counsel to determine why that language was picked, if that's the practice that you're using. But the practice that we employ and we recommend is the preponderance of the evidence. That's a standard legal term for which there's, you know, it's 51% essentially. A reasonable belief is a lot more subjective than the preponderance of the evidence.
Totally agree. In terms of proper documentation of the investigation, you should carefully and objectively document witness interviews, factual findings, and the various steps in the investigations. Different documentation methods are acceptable, but the important thing is that information is reliably, consistently, and thoroughly documented and retained. It might look like handwritten notes or typed notes, or maybe notes that are first handwritten, then typed up. It might look like drafting statements that witnesses then sign and can attest to, or similarly obtaining written statements that are actually drafted by the witnesses themselves. Could be an audio recording, but crucially, you need to obtain consent on the recording, or on the record, excuse me.
Yep, so we actually had a question about whether it's best practice to record all investigation interviews provided they receive consent. You know, in part, that is going to be personal preference of the investigator. For the most part, unless the client asks, I don't record the investigations. But that's because I feel confident in my note-taking abilities. I also feel sometimes the witness might be a little bit more guarded because they're being recorded. So if you are recording and there's nothing wrong with that, you do need to make sure that you get consent on the record or on the recording, that the witness is consenting, and making sure there's no one else in the room, because if there is, then all of those individuals need to consent to the recording as well. And just really in your opening statement, really make sure that the witness is comfortable and understands that, you know, the recording is for purposes of ensuring that you are able to, you know, accurately report the findings or the statements that that person is making. So it just depends. Some clients do ask me to record, and I do, but I really go back to my handwritten notes. One thing on handwritten notes, be very careful when you're using abbreviations, making sure that those abbreviations are not misconstrued. Your notes don't have to be perfect, but they do need to be legible and understandable. So oftentimes after my interviews, I spend quite a bit of time going through and rereading my notes, filling in the blanks. It's fresh in my mind. Sometimes I might use abbreviations quickly, and then I go, wait, I know it. This is what it meant. That's why I put this placeholder. Because, you know, after a day or so, you might forget. So it's really important to go back at that moment to refresh your recollection and make sure that your notes actually make sense to you as well.
And correct me if I'm wrong, Erica, but my understanding is that if you opt to do handwritten notes and then type them up, it's best practice to retain the copies of the handwritten notes as well. Is that right?
Yeah, I agree.
Turning now to anonymous complaints, which is a little bit different than our hypo. So let's say you receive an anonymous complaint. These kinds of complaints should be investigated in the same manner as those with an identified complainant like Jane. The method will really depend on, sorry, I'm getting messages from my employer, excuse me. Oh no, I have to go back. This has just ruined everything. Here we go. Okay.
So that's right.
Yes. Apologies, everyone. So yes, the method will depend on the details provided in the anonymous complaint. If the anonymous complaint is sufficiently detailed, the investigation may be able to proceed in the same manner as any other complaint. But if the information is more general, the employer may need to do an environmental assessment or a general survey to try to determine where there may be issues. The fact that the complaint is anonymous is not a reason to ignore the complaint. All right. Anything to add, Erica?
Yeah, this is an interesting one, simply because, normally the standard practice oftentimes is you start with the complainant, and you interview the complainant first to really assess the situation, gather some witnesses, and then from there you work your way through. With an anonymous complaint, it's going to take a little bit of detective work, for lack of a better word, to strategically determine who you're going to start with. So if it's an anonymous complaint about somebody sexually harassing another in the workplace, and the anonymous complaint gives you at least some indication of who's being harassed, are they all the females? Is it all the males? Is it the employees who are in a department? If you can start to narrow down who the potential victims could be, or the individuals for whom is being harassed, then you can start with them and then kind of work your way out. But it really just depends. Most cases, you're not going to start with the respondent, but sometimes you may not have anything to go by and you have to. So this is where, if you get those anonymous complaints, reach out to counsel to give you a little bit of guidance on where and how you should start, because there's definitely a strategy over where you start.
Fantastic. Now just a word on retaliation. Complainants and or those who cooperate in an investigation must be protected from retaliation. Employers should tell complainants and witnesses that retaliation violates the law and their policies, should counsel all parties and witnesses not to retaliate, and should also be alert to signs of retaliation. That might look like the person being ostracized or the subject of gossip. Maybe it's a termination or a demotion, a change in assignment. All of those things can be signs of retaliation. It's good practice to check back in with a complainant after an investigation is finished to ensure that the employee is not experiencing retaliation, no matter whether the allegations were determined to be correct.
So one of the things I like to do is just to not only tell the witness at the beginning of the investigation, of the interview, that they are protected from retaliation, but remind them at the end, and encourage them to report any conduct for which they perceive to be retaliatory for participating in the investigation.
Yeah, I love the idea of flagging that as a potential issue. I think that's great practice. Alrighty, so you've made the factual determination. Now what? What do you do? An employer must take appropriate remedial steps when it finds proof of misconduct, even if the behavior doesn't violate the law. Erica was getting at this earlier, that there's a distinction between a violation of policy, violation of the law. It's important not to conflate those things. And in any case, investigators shouldn't be making legal conclusions, right? So what you should do is you should impose remedial action that is commensurate with the level of misconduct that will discourage or eliminate potential for recurrence, okay? You want to look to how the company has approached similar situations in the past to avoid potential claims of unfairness or even discriminatory remedial measures. And some potential remedial measures might include things like having the person undergo training or counseling, some kind of a last chance agreement, perhaps a demotion, a reduction in salary, or another financial consequence, such as rescinding a bonus, or if appropriate, it could even look like termination. Anything to add? I think we're wrapping things up, Erica. So I just wanted to give you the opportunity. Nope.
No. Yeah, I mean, for purposes of this topic, your job is done once you've turned in your report. Once you've completed your investigation and noted all of your findings, that's the conclusion of the investigation. Then, of course, notifying the parties that the investigation has been completed and whether it was determined more likely than not, yes or no. Then it's up to the organization. So if this goes back to biases and impartiality. If you're the individual that's going to make that final determination, you may not be the right person to conduct the investigation. And there isn't necessarily a one size fits all. So this is where we do determine, what needs to be done, what kind of coaching, what kind of remedial action needs to happen so that this doesn't happen again.
Yeah. I want to do a quick plug for this CRD harassment prevention guide. A lot of the nuts and bolts of this training come from this guide. It is available for free on our website. The link is right here. So check it out. It expands on a lot of these topics and reiterates a lot of what we've talked about here today. Are there any other questions, Erica?
So there are a few in the hopper that I think are worth, mentioning. So I love, we have one participant who says, this may not come as a surprise, but some complainants are also the problem employees. Should we hold off on delivering any other disciplinary action not related to the investigation until the investigation is complete to avoid a retaliation claim? So that's really going to depend. I know that's not an answer to your question, but it's really hard to say when we don't know what those claims may be. Generally speaking, a retaliation claim is going to be linked to the fact that the employee brought a complaint. If these other disciplinary issues are completely unrelated to the reason that they're bringing the complaint, then there's nothing that in the law that's going to say no. Now, could the employees still claim retaliation? Of course they can, but that's when you're going to have to weigh the workplace conduct, the conduct for which they're getting disciplined for, and the allegation raised in the complaint. Oftentimes they're going to be linked because oftentimes we notice or we see sometimes that where an employee is subject to discipline and they believe they might be terminated, they file a complaint to stop everything. And usually, or I shouldn't say usually, but more likely than not, there's my preponderance of the evidence, it is linked to whatever performance issue, in which case, yes, we're going to have to go through that investigative process. If the complainant refuses to participate in the investigation, should you still conduct it? Yeah, I mean, like Rashida had mentioned earlier, there are many times where an employee might come to you and say, look, I need to tell you about what happened, but I don't want anything done. I don't want anything to happen. Usually that's because they're fearful of retaliation and they're fearful of what's going to happen to them. But as an obligation and under the laws of the state, you still have an obligation to look into it. Now, like I said, the term investigation is a pretty meaty word. And when I hear investigation, I always think of this like very formal process, but it's not. That could be you reaching out and asking a few questions, finding out what happened. It's talking to individuals who may have information related to the alleged complaint. What if no proof of misconduct or evidence is found to someone's allegation, but there's also no reason to believe they're lying? That's where we go back to those credibility factors, right? That's where we have to say, look, this witness is very credible because, or the complainant is very credible because, or we look at it's plausible that this happened because we have all of these email conversations that aren't as kind as one would hope, or whatever the case may be, you're using the evidence that you've received to make that determination. So that's where we really do have to rely on the credibility factors and where our investigation hinges on the credibility of the witnesses. So that certainly can be very tricky. Favoritism, that comes up a lot. Allegations of favoritism, however, are those allegations that should be investigated, particularly if favoritism is based on a protected class. So that's going to depend upon a number of different factors going into what the claim of favoritism is about. So again, it may require just a preliminary look under the hood, and based on what you found, maybe you do determine that there are protected classes involved, in which case you do need to have a more formal investigation. Sherry, what verbiage do you use in determinations, just whether it was sustained or not, or do you use any other types like exonerated or unfounded? So exonerated is more of a conclusion, so we're going to stay away from that. Similarly, unfounded, that's not really going to be what I'm going to hang my hat on. I use the preponderance of the evidence standard. It's more likely than not that Rashida did not say an inappropriate comment in the break room, and then I use my evidence to support my finding. Why is that the case? Now, if so-and-so said, Rashida said a really nasty word, but no one corroborated it, none of the witnesses said she said that, then I could say, you know, the claim that she said an inappropriate word was not supported by testimony from other witnesses. You know, so you're saying it's unfounded without saying it's unfounded, if that helps. Let's see. I think we got it. Let's see. Oh, this is excellent. Wait a second. A newly hired place to let's see. There was one about a romantic relationship that was coming into the workplace. Now, oh, here we go. So what happens if the complaint has to do with two employees who had a relationship? It was a personal matter, and now it's being brought into the workplace. You know, what happens outside of work can still be a work-involved situation worth investigating. You know, we always say if it's a personal relationship, but the employees work together and now there's conflict in the workplace, it becomes the employer's problem, even if it originated outside. You know, similarly speaking, we always talk about in trainings and on harassment and prevention, it's, you know, it's not where you are, it's who you're with. Time and place matter. So if we're at an office conference, if we're at the holiday party and we may not be on the clock, we may not even be in our remote setting or in the office, we're at some bougie restaurant with, you know, libations flowing, and we forget that we're still with our coworkers. So we still have to pretend like we're in the office as far as how our conduct takes place. And if there's something inappropriate and you hear about it the next day, that is something that you're going to have to investigate.
Cool. So I just want to be conscious of time. Yeah, it looks like people are starting to hop off.
You know me, I could just keep talking and talking and talking. So yeah, I want to thank Rashida. Rashida, I want to thank you so much for coming, and I love doing these with you. We're going to be back again next month for another exciting topic. If you wouldn't mind rolling the slide, just to give folks a chance to take a peek at some of our upcoming trainings. One more, the investigation training is coming up. It's October 4th is the first day, and as you can see, it is a 3-day event, so it is extremely intensive. It will give you so much more than what we did today. Today was just sort of on the surface. This is what you need to know. This will tell you how to do it. And then, of course, we have other upcoming webinars and seminars, in addition to Rashida and I entertaining you again next month.
Yes,
so
always a pleasure. Sorry, go ahead.
Do you have anything more to add, Rashida?
No, I love doing these with you, Erica. It's always a great time, and I so appreciate your expertise and just learning from you. So I'm very, very grateful, and I look forward to next month.
All right. Take care, everybody.
Bye, all.
Bye.